Hello and welcome to BYJU'S Exam Prep IAS. Let's get started and look into our daily quiz. Before we start with our today's practice questions, we have two important announcements. BYJU'S Exam Prep IAS would be conducting a national scholarship test which is scheduled to be conducted on 14th of August 2022. What is that you have to do? Follow the link given in the description box, give the necessary information and you would be able to win some attractive scholarships. The other is in reference to the weekly current affairs explain session. As part of the explain session, tomorrow's topic would be data protection bill withdrawn. So please make sure that you attend this lecture live on our YouTube channel at 8 p.m. so that you understand everything about this topic. Let's get started and look into the first question. In which amongst the following cases did the Supreme Court ensure that convicted criminals don't contest elections and find a place in the parliament and state legislature? Keher Singh versus Union of India, Kyoto Holohan versus Zachilu and others, Lily Thomas versus Union of India, Lok Prahari versus Union of India and others. Which judgment led to the convicted criminals not entering the parliament and the state legislature? The answer to this is Lily Thomas versus the Union of India. Why have we taken this practice question? Because this article on the Hindu speaks about Supreme Court to take a plea to ban convicts from polls for life. Let us try and understand what is this Lily Thomas judgment all about in brief. When we look into representation of the People's Act of 1951, we have one of the important sections which is section 8. Section 804 of the Representation of the People's Act allowed convicted MPs, MLAs and MLCs to continue in their post provided they appealed against their conviction or sentence in higher courts within 3 months of the date of judgment by the trial court. What do we understand by this? Let me simplify this process for you. Let's say we have an MP or an MLA. Let's say he has committed an heinous offense. It can be a murder or it can be a sexual offense, whatsoever it is. In that case, where does the trial take place? It takes place in the lower court, in the sessions court, the trial court. So what happens? The trial court looks into this particular issue and it ultimately convicts this MP or an MLA. So the court says, yes, it is this person who's committed this heinous offense. So there is conviction that happens. So penalty is imposed on him, punishment is imposed on him. So earlier, according to section 8 of 4, it said that if the trial court so convicts and if this person appeals to the higher court, let's say the high court, in that case, this person will continue to be the legislator, said section 8 of 4. So what does this mean? It meant that he could continue to be the legislator despite being convicted if this person appeals to the higher court. But then the Supreme Court of India in Lily Thomas case went on to say that the elected or the non-elected MPs and MLAs would be disqualified with the immediate effect if they were convicted in a criminal case by a trial court, and the saving clause under section 8 of 4 will not be applicable. This clearly meant if the trial court convicts them, even if they appeal in the higher court, in that case they will be disqualified to become the MPs or the MLAs, says this landmark judgment. In this article, the Supreme Court is considering a plea seeking a lifetime ban on people convicted of offences from contesting elections and becoming the MLAs. As of now, it is a 6-year ban that is imposed, but the Supreme Court is considering whether this should be imposed for the lifetime. Now let's look into the next practice question. Consider the following statements. In case of a conflict between the central law and the state law on a subject enumerated in the concurrent list, the central law prevails over the state law. If the state law has been reserved for the consideration of the president and has received the assent, then the state law prevails in that state. The Malimat Committee, constituted by the Atal Bihari Vajpayee government in 2000, favored making section 498A of the Indian Penal Code, that is the dowry harassment, a bailable and a compoundable offence. Which of the statements given above are correct? The answer to this is 1, 2 and 3. Why have we taken this practice question? Because this article here is speaking about former President Kovind gave nod to 2019 MP legislation. Let us try and understand what are these options. When you look into the first option, it says in case of a conflict between the central law and the state law on a subject enumerated in the concurrent list, the central law prevails over the state law. What do we mean by it? We have the 7th schedule. In 7th schedule, what we have is the union list. Then then what we have is the state list, and then what we have is the concurrent list. When it comes to the union list, it is the central government which would be able to make the laws. The parliament would be able to make the laws. When it comes to the state list, the state governments would be able to make the laws. But when it comes to the concurrent list, both the central government and the state governments would be able to make the laws. Let's say, for example, when it comes to the criminal laws, what we have is it is placed in the concurrent list. So central government would be able to make the law, state government would also be able to make the laws. But what if there is a conflict between the state law and the central law? In that case, whatever the central government has made the law, that will prevail over the state government. So the first option is right. When you look into the second option, if the state law has been reserved for the consideration of the president and has received its assent, then the state law prevails in that state. What do we mean by it? Let's say there is a state law. This state law is being referred to the president. Now the president has given assent to it. He has given permission to it. In that case, even if the state law is against the central government law, in that case, because the president has given the permission to the state law, that will prevail, says the second statement. So the second statement is right. When you look into the third statement, yes, the Malimat committee constituted by the Atal Bihari Vajpayee government in 2000 favored making section 498 of the Indian Penal Code, which is to do with dowry, a bailable and the compoundable offense. This is what this article currently goes on to speak about. All the three statements are right. So the answer to this would be 1, 2 and 3. Now let's look into the next practice question. Which amongst the following is not correctly matched as per the Chola inscriptions? Velan Vagai, land of non-Brahmana peasant proprietors. Palichandam, land gifted to Brahmanas. Shalaboga, land gifted to temples. Which of them are not correctly matched? The answer to this is 2 and 3 only. Why have we taken this practice question? Because this article on the Hindu makes a reference to the Cholas. So when we speak about the Chola inscriptions, they have different categories of land. When we speak about Velan Vagai, it is the land of non-Brahmana peasant proprietors. When we speak about Brahmadeya, it is land gifted to the Brahmanas. When we speak about Shalaboga, it is the land for the maintenance of a school. So when we speak about Palichandam, it is land donated to the Jaina institutions, and Devadana or Tirunal Mattukanni is the land gifted to the temples, because it is only the first one which is correctly matched and the second and third are not properly matched. The question is asking for not correctly matched, so the answer to this would be 2 and 3 only. Now let's look into the next practice question. With respect to Third Anglo-Mysore War, which of the following statements are correct? During the initial phase of the war, Tipu defeated the English under Cornwallis. The war ended with the Treaty of Mangalore. It was during the Third Anglo-Maratha War. Tipu's two sons were taken as hostages by the British. Which of the statements are correct? The answer to this is 3 only. Why have we taken this practice question? Because this article on the Hindu makes a reference to Tipu Sultan. Let us try and understand what are these options. When we look into the first option, during the initial phase of the war, Tipu defeated the English not under Cornwallis, but instead it was under General Meadows. So basically, the English initially started siding with the Travancore and attacked the Tipu. In 1790, Tipu defeated the English under General Meadows, and in 1791, what we had is a change of leadership. That is when Cornwallis enters into the picture. So initially it was not Cornwallis, but it was General Meadows. When we look into the second statement, the war ended with the Treaty of Mangalore. This is also wrong. Why? That is because it ended not with the Treaty of Mangalore, but it was Treaty of Seringapatam or Srirangapatnam. And when we speak about the third statement, yes, the third statement is right. It was during the Third Anglo-Mysore War. Tipu's two sons were taken as hostages by the British. This statement is right. If we speak about the first Anglo-Mysore War, it was fought between the Kingdom of Mysore under Hyder Ali and the British East India Company, which also had the assistance of Nizam of Hyderabad. The first Mysore War ended with the Treaty of Madras. The second was with the Treaty of Mangalore. The third was with the Treaty of Seringapatam. This can be probably asked in your preliminary examination, so please remember all these important treaties. Now let's look into the next practice question. With reference to Tea Board Board in India, consider the following statements. The Tea Board is a statutory body. It is a regulatory body attached to the Ministry of Agriculture and Farmers Welfare. The Tea Board's head office is situated in Bengaluru. The board has overseas offices at Dubai and Moscow. Which of the statements given above are correct? The answer to this is 1 and 4 only. The first statement is right. The Tea Board is a statutory body. It was created under the Tea Act of 1953. So the first statement is right. When you look into the second statement, it is a regulatory body attached to the Ministry of Agriculture. This is a wrong statement because this is with the Ministry of Commerce and not with the Ministry of Agriculture. Second statement is wrong. When you look into the third statement, it is not head office at Bengaluru, but instead it is in Kolkata. So the third statement is wrong. And when you look into the fourth statement, yes, the board has the overseas offices at Dubai and Moscow. So the answer to this would be 1 and 4 only. And this happens to be a previous year question from the year 2022. Now let's look into the fact of the day. The fact of the day for today's discussion is Langya virus. This article here is speaking about what has been discovered right now in the eastern province of China. A new zoonotic disease has been discovered in China's two eastern provinces where about 35 people have been infected. So China has become a den of diseases. While the world is just recovering from COVID-19, China happens to be coming up with another new virus. So it has become a den of viruses is what is this article speaking about. First, we have to understand where was this Langya virus discovered. The Langya virus was discovered in the eastern China during the surveillance of patients. The Langya virus happens to be a type of Henipa viruses. The types of Henipa viruses that had been identified prior to this included Hendra, Nipah, Cedar, Mojiang and the Ghanaian bat virus. When we speak about this Henipa virus, this happens to be categorized under biosafety level 4. So we have different types of biosafety level. One is the BSL1, BSL2, BSL3 and BSL4. And when it comes to the Langya Henipa virus, it belongs to BSL4. What is this BSL1? Microbes not known to consistently cause disease in immunocompetent adult humans. Then we have BS2. Microbes pose moderate potential hazard to personnel and the environment. Example happens to be cold viruses. Third happens to be BSL3, which is indigenous or exotic microbes that may cause serious or potentially lethal disease via inhalation, SARS-CoV-2. And finally, what we have is exotic agents that pose a high risk of aerosol transmitted laboratory infections and life-threatening disease that is frequently fatal, which are having no vaccines or treatments. Some includes Ebola virus or the smallpox virus, and in the present situation, Langya happens to be a BSL-4 one. Where has this Langya virus come from? This virus RNA has been predominantly found in shrews, which may be its natural host. In all likelihood, the virus may have jumped from the animal to the human beings, and it is predominantly found in the shrews. This happens to be the natural host of this particular virus. What about the human to human transmission? As of now, there are no clear answers yet. People are trying to study more about it. There are authorities investigating about it. As of now, when you look at the data presently, there is no answer for the human to human transmission. What are the symptoms? When we speak about the symptoms, the study looked at 26 patients with only Levi infection to identify the associated symptoms. While what are the symptoms included? Fever, fatigue, cough, nausea. Then they also had headache and vomiting. They also had impaired liver function, kidney function impacted. Few patients were accompanied by abnormalities of thrombocytopenia, leukopenia, impaired liver and kidney function. Thrombocytopenia is low platelet count, while leukopenia means a fall in the white blood cell count, in turn reducing the body's disease fighting capability. These are some of the facts with respect to this virus. As of now, we do not have any vaccine to this particular virus. It is this that we have to understand with respect to this article. So this is it for today. Thank you for watching. All the best.